Good morning. I'm Susan Walden, and I'm here today with Samuel Bearman to discuss automobile accident claims. Good morning, Mr. Bearman.
Good morning.
Questions about automobile accident claims.
Yes.
When someone is involved in an automobile accident, what types of claims are there?
There can be a property damage claim for the damage to the vehicle. There can be a claim for medical bills. There can also be a claim for injuries if the person has been injured. So those are the three dominant claims to consider in a motor vehicle accident.
And is an attorney always needed to represent somebody who's been in an automobile accident?
No. In fact, one of the reasons for the no-fault program that we have is to try to eliminate the need to go to court every time there's an automobile accident, so that the insured, the person involved in the accident, particularly when he's not at fault in the accident, that person hopefully will get his or her vehicle repaired without any problem, get his medical bills paid by his own insurance company under the no-fault program, and if those two things get taken care of, certainly an attorney is not needed. If that person is injured, it seems like those claims don't get resolved as readily as the property damage claim or the medical bills claim. And oftentimes that's where a person decides he needs to get an attorney involved for an injury claim. But if it's just medical bills and property damage, hopefully no attorneys needed, because hopefully the insurance company or companies take care of the claims without any difficulty and in a timely manner.
Help us understand the difference between medical claim and an injury claim.
Medical claim, when I talk about a medical claim, it's really medical bills. The injury claim is very different from that. The medical bills in Florida, under the no-fault program, the medical bills are paid by the insured's own insurance company. In other words, if two people are in an accident, it doesn't matter who's at fault. The person who sustains medical bills has those bills paid by his own company, not the other company, even though the other driver may be at fault. So there's the issue of the medical bills getting paid. But if there are injuries, particularly injuries that turn out to be permanent, then the other driver's insurance company is going to be responsible, and if that other driver has insurance. And in that case, an attorney can really try to ensure that the client gets fully compensated for his injuries. Very different from just the medical bills.
And what can an attorney accomplish for someone who's been injured in an automobile accident?
Well, again, on the claim for injuries, it's sometimes difficult to grasp the concept of getting compensated for injuries. But what I mean by that is when someone has an injury, that person likely has pain, has anguish, has loss of ability to enjoy life if the injuries are serious, inconvenience, suffering. All of those things are compensable, which is not as easily comprehended, I guess, as the idea of if you have medical bills should be paid. That's out-of-pocket commitments. If you have your automobile damaged, the automobile should be repaired. Theoretically an out-of-pocket expense. How do you compensate somebody for an injury? That's not quite that clear. And again, the idea is that the law recognizes that it can't heal the injury. All it can do is, and this has been done for hundreds of years, all it can do is compensate the person who's injured for that person's pain, anguish, suffering, loss of enjoyment of life, all those things that have resulted from the injury. The law can't do anything else other than compensate. If the law could heal the injury, it would, but it can't. And so that is a claim that oftentimes does not seem to get resolved between the victim of a motor vehicle accident and the other party's insurance company, and that's where an attorney can really help his client.
And what is the role that insurance plays in an automobile accident in a claim arising from such an accident?
If there's no insurance, things are certainly different. If there is insurance, again, the damage to the vehicle should be readily paid. The medical bills are paid by the insured's own insurance company. If there is no insurance, things are completely different. Trying to get somebody who caused an accident to pay out of his own pocket to repair the other driver's vehicle is difficult, simply because most people don't have the money readily available to pay for damage to somebody else's vehicle. If a person doesn't have insurance and has medical bills, then he or she has to come out of pocket to pay for those medical bills, which is a very difficult thing to do, again, because so many people simply don't have the money. And to try to have somebody who's been injured in a motor vehicle accident recover for his injuries from the other driver, if the other driver doesn't have insurance, is extremely difficult because, again, of the shortage of money. There is such a thing as what's called uninsured motorist coverage. So if two people are in an accident, the one who is not at fault, the victim in the accident, who is injured, if the other driver doesn't have insurance, if the person who was injured has what's called uninsured motorist coverage under his own policy, then he can be compensated for that for those injuries under the uninsured motorist coverage part of his own policy. So the point is, you can buy coverage to protect you against being hit by somebody else if that somebody else doesn't have insurance.
I've heard the term crash-worthy. Please explain what that means.
Vehicles are going to be in accidents, unfortunately. And so the car manufacturer has a responsibility to build the car in a way that reasonably anticipated accidents will be able to be handled by the vehicles. You don't want a vehicle that flips over when it's hit at a speed of 20 miles per hour. You don't want a seat belt that releases the occupant at a speed of 25 miles per hour. So you've got to build a vehicle in such a way that those things don't happen. You don't want a vehicle that's hit in the rear at 30 miles per hour to explode and kill the occupants of the vehicle. So that's what is meant by crash-worthy. It can handle the reasonably anticipated accidents that occur without really jeopardizing the occupants of the vehicle.
If an attorney does get retained regarding an automobile accident, how does he get paid?
The way we handle these cases is on a contingency fee basis, where if we're successful, get paid a percentage of the recovery. So we don't charge any fees. We don't charge any case expenses unless we're successful with the claim. I think other attorneys do that as well, probably most attorneys, but that's the way we handle these cases.
Thank you very much.
Thank you.